Well, let me go ahead and get us started today. Welcome, everyone. I'm so pleased to welcome you to the ALS Teach-In webinar series on professional independence and the legal profession. I'm Kelly Testy, and I'm currently serving as the Executive Director and the CEO of the Association of American Law Schools. And we are the Learned Society for Law Faculty in the United States, and we are also a membership organization that is delighted to be joined by 175 schools who are committed to excellence in legal education as we are. So it's our honor to host this webinar series, and I welcome all of you and really appreciate you joining us today. This is a six-part series that grew out of our annual meeting that we hold every January. And at that annual meeting, our then President, Austin Parrish, Dean of UC Irvine, had some wonderful presidential panels that engaged these issues, and this webinar series has grown from that. In addition to our annual meeting every year, for those of you not familiar with ALS, let me just say, please visit aals.org because we host so many wonderful conferences, webinars, and other events that helps the legal education community connect with one another and grow stronger. And in the time we're all in our world, we need that. We need to work for the common good as well as the rule of law in terms of making our individual and our collective contributions. My colleagues will put in the chat some of our upcoming events, including a large clinical law conference, a new law teachers conference, and so much more. So with that, I want to say a thank you to everyone who's participating today, and Austin Parrish, our past president of the Association of American Law Schools, will now say a word of welcome and introduce that panel. Thank you, Austin. Great work.
Great. Well, thanks so much, Kelly, and great to have everybody on the Zoom call. I'm going to make this very quick, just two quick things. So one, next week, we're back on our Wednesday at 6 p.m. Eastern Time, 3 p.m. Pacific Time. University of Washington is hosting next week. And then the week after, we'll then have Indiana University Maurer School of Law, then Georgetown, and then Harvard. So make sure you key into all the different webinars that are coming up in this series. I'm incredibly excited tonight that we've got really just an absolutely fantastic session on a topic that I'm really interested in, and really grateful that Deborah Pearlstein, who's the director of the program in law and policy at Princeton University and the Charles and Marie Robertson visiting professor in law and public affairs, is taking the lead on this. She was absolutely brilliant in our presentation at the annual meeting. And so with that, I'll turn it over to Deborah for this night's panel. Deborah, thanks so much for joining us. I'll turn it over to you.
Austin, thank you. And huge thanks to Kelly Testy as well, and everybody at AALS for putting together this extraordinary webinar series on professional independence and the legal profession. This is our second episode. As they said, I'm Deborah Pearlstein with Princeton University. In case you missed it, the video of last week's opening episode is now available on the site where you registered, and we pasted in the chat there. I'll be pasting a few other writings and relevant pieces of information in the chat as we go along tonight. The discussion last week in that session focused on the executive orders that were issued just about exactly a year ago that targeted commercial law firms based on the president's view that the firms had represented clients or causes that he disagreed with and disapproved of. Ongoing administration actions targeting commercial law firms have continued since then. Last week, they discussed the firms' varied responses. Some firms sued, arguing the executive orders were unconstitutional. Other firms struck deals with the administration. They talked about the status of litigation. The firms that challenged the legality of those orders have all won their suits in the lower courts. Those cases now sit pending in the Court of Appeals in Washington, D.C. And they also discussed in the last panel the resulting significant impact, notwithstanding these court victories, on the willingness of major firms to challenge any administration action, pro bono or otherwise. To continue this discussion and really to pick up where that discussion left off, I'm honored to be joined by an extraordinary set of panelists this week to discuss strategies that American lawyers and judges have pursued in response to different kinds of government pressure on the practice of law. all of our panelists this evening have been involved in those efforts in central ways. Let me introduce them briefly before we get started. Judge Shira Schindlin was a judge on the U.S. District Court for the Southern District of New York and is now an active mediator. She is part of coalition of dozens of retired federal judges and others who have advocated for law firms and lawyers and law professors to adopt a set of principles for the independence of the legal profession. And we'll discuss that work tonight. Neil Chatterjee is a partner with the firm of King & Spalding and founder of a group called Law Firm Partners United, which is a coalition of, I think now more than 800 partners in major law firms in the United States that was formed in response to threats to the right to counsel. And Greg Nunziata, who is the executive director of the Society for the Rule of Law, which is a growing organization of conservative lawyers and judges who were active in amicus briefing in the executive order cases and have been increasingly active in other initiatives to push back on attacks against the rule of law and the legal profession itself. So with that, in the hope of keeping this as conversational as possible, I'm going to pose questions sort of to the panelists individually and then to everyone as a group, and leaving time, I hope, to address at least some of the questions you might have. Let me encourage you to enter them in the Q&A function, not the chat function, but the Q&A function. And time permitting, we'll get to them over the course of the hour as we proceed. So, Judge Schindlin, if I can, let me start with you. In the wake of the attacks on the law firms and the evident ongoing impact that the firm response has been having on firm behavior, last week, the panelists discussed how chilled firms were or seemed across the board in what kinds of cases they would take on. You and another former federal judge, John Jones of the Middle District of Pennsylvania, retired federal judge, co-authored an op-ed in the New York Times back in January, calling on lawyers and law firms and bar associations and law faculty and corporate counsel and nonprofits to join you and a bipartisan coalition of other retired judges in signing on to what you called Principles on Professional Independence. And I'll shortly here in a second post both your Times op-ed and the principles themselves in the chat. Can I ask you to start just by telling us briefly where the idea for the principles came from, why you thought drafting them and starting with judicial signatories might be part of a useful strategy to ultimately sort of shift behavior?
Yes, well, you've asked a lot of questions at once, but I'll try to cover them all. So first of all, I would say two very important phrases. Silence is not an option. Please, would everybody keep that in mind. At times like this, silence is not an option. Second phrase, we are stronger together. That's very important because what the executive orders did was to have some firms agreeing to make deals, so to speak, with the government, other firms fighting. And that's disarray. We are stronger together. So with that background, let me say how the idea originated and why it's important to judges in particular. So Professor Pearlstein here held a think tank type session with a lot of very prominent lawyers and some former judges. And I was very honored to be at that event. And we talked about what do we do to push back, to respond to these executive orders that are threatening the independence of the legal profession. And as a former judge, I said to myself, well, of course it impacts the judiciary because judges can't just write on any issue they feel like. They can only respond to cases that are brought to them. So if the lawyers are not independent and can't bring cases that are important, then you won't get judicial decisions of importance in setting out what the law should be. So the judges need an independent legal profession. That said, I then worked on an idea with the help of Professor Pearlstein and others on developing a very short set of principles governing the independence of the legal profession. It is going to be posted while we're talking, but you shouldn't be reading while we're talking. So I'm going to summarize them real quickly, sort of the abbreviated version of what's already a short set of principles. So the first one says, people should be free, lawyers should be free to practice law, free from government coercion or any retaliation for protected First Amendment activity, which includes representing clients and all of their claims, whatever they may be, including suits against the government. donating to causes of concern to those lawyers, or expressing beliefs regarding the value of equal opportunity for all. Second, respect for the rules of professional conduct, which is very simple, duty to represent clients on the issues that they need representation for. Three, providing legal services to those in need, very important. We call that pro bono publico, and I'll say something more about that in a second, but either directly providing those services or to an organization that they might assist in providing those services, and protecting the rule of law. If we have time, we can talk about that phrase, which everybody knows, but we don't always share the same definition. But anyway, making sure that people, lawyers can practice safe from government interference, and providing equal access to justice. Four, very important, maintaining public confidence in the actual and perceived integrity of the legal process. Right now, when you read and hear what's being said, it's hard to believe there's going to be much public confidence left, but there has to be public confidence in the legal profession and in the courts. Fifth, encourage others to support these principles, including clients, which means businesses. It also means bar associations, it means federal and state governments. Finally, refusing to accept representation if there's a condition of doing so would violate any of these principles. So just one more quick comment. Pro bono publico means free services for the public good. It does not mean free services for the particular issues that the current administration wants lawyers to give their time for free. That's not pro bono publico. So that's an important distinction that you should keep in mind. So I think that covers, most of the questions you asked. If it didn't, tell me which one I missed. I'll answer it now.
So I guess maybe just one more word. Thank you. That was tremendous. Let me ask you to say just one more word maybe on why principles were thought, or why you thought principles might make a difference. What's the point of having people sign on to these? Why might this actually succeed in changing behavior? What was the idea of having, a bunch of lawyers or firms sort of commit to these on paper?
Well, I think it's where I started when I said we're stronger together and silence is not an option. If the legal profession acts cohesively and takes a stand together and doesn't accept anything that intrudes on their independence, that's what we need to do. We need to stand up, because if the lawyers are silent, and we know this from history, then the country can slip away from its democratic roots. We count on the legal profession not to be silent, not to put their heads down and look away. Very important that we stand up for our democracy and for the rule of law. So maybe it was a repetitive answer, but I think I now have covered what you asked.
Thanks. So let me, given that we're talking about the role of firms and the response of firms and the sort of collective action problem that you described, let me turn to Neil, who's obviously at a firm. You now lead this coalition of hundreds of other major law firm partners who originally formed around filing amicus briefing in the litigation that followed the executive orders. Can you tell us a little bit about what your experience was in building support among firms or firm lawyers to sort of push back against some of the executive orders that were targeting them? Was your sense that it was sort of opposition to some of those kinds of basic commitments that the judge was just describing? And then what do you see the role of that kind of coalition to be going forward?
Yeah, so, there was a very significant impact on the way law firms do business, because, law firms, big law is more of a business than it is a profession today, right? I mean, if you're talking about, just as an example, Kirkland & Ellis, an equity partner there owns less than 0.3% of the firm, an equity partner of the firm. And so if any individual partner, maybe except for the 10 people at the top, think they have a meaningful role in deciding an outcome of what a law firm's going to do, they're kind of fooling themselves, right? I mean, just as a practical matter, on raw percentages alone. And you have to recognize at first that people were really frustrated with law firms, but law firm partners sat in a little bit different place, because no one knows about that 0.3% I talked about. Instead, Clients reach out to the partners that they work with and want to hold them accountable. The associates and the staff reach out to the partners and hold themselves accountable. And they may go in and talk to their law firm management about what they want to do, but ultimately the business is going to do what it has to do, just like any other business will. What I did in forming Law Firms Partners United, I'll start with, it was about a year ago, right in the middle of March Madness. I woke up on a Sunday morning and I was like, less than 10% of the AmLaw 200 signed on to an amicus brief where 500 other law firms signed on. And it was heavily driven, I think, by fear. It was that, look, the government, even if they don't have an executive order against you, we all interact with government in different ways, and they can slow roll things. They can make things harder for us when we're trying to do things for our clients. So the businesses had a legitimate reason in serving their clients why they didn't want to participate. But I woke up and I was like, we have to have a space for law firm partners to talk about this. We need to figure out collectively, how do we discuss with our clients, with our staff, with the associates, independently of the law firm, how do we address the way we feel about it when we want to support the rule of law? Now, I have a very long social media background. I represented Zuckerberg against the twins. I represented almost every social media company that's been around for the past 30 years. And I decided I'm just going to form a private LinkedIn group. You just form it, and I'm going to empower everyone to decide how public they want to be. And then we're all going to get together and just people will start talking about it. And inside that closed set, there are young partners that are seeking mentorship from more senior partners. There's now the dialogue has slowed down a little bit, but there was a lot of dialogue and just information sharing and seeking guidance. And kind of overnight, and a little bit surprisingly to me, but in retrospect, maybe it shouldn't have been, within 48 hours, we had 150 members. Within a week, we had 600 members. Today, we have about 870, 880 members. We would have had probably more than 870, probably closer to 1,200, if some law firms weren't really bent out of shape that their partners were members of our group. And I was very clear from the day I launched it that I was operating independently of my law firm, that I was an owner in the law firm, but the law firm did not own me. And we were going to independently speak out to support the rule of law. We decided within 2 weeks, I said, does anyone know how to form a nonprofit? I had no idea how to do it. I had 5 lawyers that say, we're nonprofit lawyers. And we organized a conference call among them. And they said, let's figure out what we are. Within a week, we had formed a nonprofit organization. Then I said, well, I do know something about litigation. And I know some really great appellate litigators. And I called a couple of my friends and I said, would you do an amicus brief for us? And what I'll tell you, Deborah, is the most inspiring part of probably the last 30 years of practice that I've been on was when I organized town halls. Because what we did was we created drafts of the briefs, and then we had town halls where everyone was allowed to say whatever they wanted to say about the brief. And the goal was to get as many people to put their name on the brief in addition to our organization. And we had people that were Trump supporters, we had people that were conservatives, we had people that were liberals, and they were all collaborating together in a very respectful and productive way. And I have to say, the initial brief was probably a little bit fire and brimstone. The ending brief was really, and I credit Eric Olson for this really, who was the driver of our brief. It was a really masterful work of a nonpartisan brief that kind of set forth why an attack on the rule of law was wrong. In the next weeks, we're going to be submitting another one on the appellate courts, and I'm not going to say what's in there yet, but you can imagine when we talk about the rule of law is a fundamental case that we all study in law school is Marbury versus Madison. Imagine for a moment if the people who litigated Marbury versus Madison were going to be politically, harmed by filing that lawsuit. Like, it's completely non-controversial today, right? That the courts decide the law and can actually second guess the president, and executive orders and things like that have been struck down. Imagine for the moment if that issue was never presented to court. Like that's what the attack on the rule of law fundamentally does. Like we can talk about the more controversial issues. That's completely non-controversial. So really what I was very inspired by was the fact that we had so many people join and want to participate and continue to participate to this day. The other thing that I learned was that if you think of the No Kings March that happened the other day, for every one person that's in the road, there are probably 10 other people that are looking at it with some admiration and feeling the same way, and it helps motivate them to, in whatever way they're comfortable, participate. And I absolutely felt that our 870 and change people were in fact impacting an entire legal community about how they felt about their ability to play some role, big or small, that made a difference. I'm just going to end with this, Deborah, and I know I've already talked too long, is I was fortunate enough to be named Lawyer of the Year for the American Lawyer last year. And one of the things that I told people was, this is the best time in our life to be a lawyer. Because when you talk to people that were alive in the 40s and 50s that have become these legendary judges and practitioners, they don't talk about the billion-dollar case that they won. They talk about going for fighting for voting rights in the southern part of the United States. And they talk about helping a little girl go to school. And in my years of practice, I have not had a time where I'm really feeling like I'm getting to push the envelope on fundamental issues of the way our government's run. And if you want to capture that moment, if you want to be on the right side of history, you have to recognize that as stressful as it is, this is the best time in our life to be a lawyer, but you have to speak up to do that.
So thank you for that. I want to come back to some of those points in just a bit, but let me get Greg in part of the conversation because it's one thing to importune lawyers and current law professors and others to engage. It's another thing to engage students. But one of the interesting parts of the conversation last week, one of the law firm partners on the panel noted that to the extent the law firms had felt any pushback from their own constituents, whether clients or their efforts to recruit new lawyers, one of the impacts that they noticed was the firms that signed deals with the administration was a significant impact on recruiting new law students as law students started to organize and track which firms signed deals, which didn't. Now the principals can serve that role, which firms have signed on to principals, which haven't. You've spoken eloquently with students and about what their role can be. Other than things like that, how do you think students should think about their own role and responsibility in this moment when they're navigating this environment sort of at the beginning of their careers?
That's a great question, and I think some of those anecdotes are encouraging. I'm on a lot of law school campuses. I probably visit 3 or 4 a month, and I think the impression I get is a mixed one. Some campuses have, I guess I'd say, stronger rule of law cultures than others, and I think it's important for students to take time in law school to learn about what it means to be a lawyer, and that it is a profession, not merely a craft, and it's a profession that plays a key role in making our society function the way we want it to function. I think, this is a little bit of a hobby horse for me, but not a lot of law schools actually teach the rule of law as a concept, right? Even though there's hundreds of wonderful books spanning political science and philosophy and sociology and various other fields, just thinking about what law is and how it developed and what it means. And I think too few lawyers are steeped in that. So I really encourage students to spend some time in law school seeking out classes that touch on that. And if they don't, to try to do some reading and reflecting themselves. I mean, I think it's important first that we as lawyers educate ourselves about what the rule of law means, because then we really are ambassadors kind of to the rest of the country about these values. One of the things about some of the more controversial, I think, actions this administration has taken is it's been deliberate in choosing enemies, targets that might not be popular. And with all apologies to Neil, partners at elite coastal law firms are not necessarily the most popular or sympathetic figures in the world, and they're easy to demonize. So, it's important to have, all of us lawyers in the country understanding the value that law plays and what it means if we live in a world where lawyers can be punished and intimidated and scared away from taking cases. As the judge said, I think this is really important. That the courts are one of three indispensable branches, but maybe the most indispensable branch. Montesquieu, who we get the concept of separation of powers for, wanted all three separated, but the most important branch to have separated, independent, and strong was the judiciary. And there's been an assault on the legitimacy of the judiciary, which is concerning. And the administration is trying to delegitimize opinions that are coming out of it, but we don't even get to those opinions if lawyers aren't willing to bring cases. And so this is a really, really important concern that we all should have. It was for us at the Society for Rule of Law. We had primarily worked on education, not advocacy. And these cases were the first cases where we submitted amicus briefs because we felt so strongly about the threat here. And I've been encouraged. Our membership is principally, not exclusively, but principally right of center lawyers. We try to speak to the right of center, and we have amongst our members people who voted for Trump 3 times. And I think these executive orders are the first time that some of those members got really concerned about the way things were going and wanted us to really engage on it. So lawyers, law students are at the start of this, but I really hope they think deeply about this and think about how they can make their education rooted in the rule of law and then bring it forward in their practice.
Thanks. And just as you were talking, I put a link in the chat to a blog, or I think your Substack post that you wrote about the rule of law in that context, and also some suggestions for students and things they could do in this space. So let me turn back to Judge Shinlin, I think now, and ask about sort of the plan going forward. So I started and opened by saying, the litigation was being won in the courts, at least so far, and the prospects seem good for it continuing to win on appeal, but we will see. In the meantime, right, how do we get firms to move off the willingness to kind of take cases? So let me ask you what the plans for next steps are. I know because I now sit on this advisory board for your coalition of judges, that you saw hundreds of attorneys and professors and the New York City Bar Association sign up in the wake of the New York Times op-ed. The list of retired judicial signatories is now over 70. And
Well, I'm going to tell you that.
Okay, so tell me, so I'll stop asking. Tell me what kind of response you've seen, and do you expect to reach out more to schools or corporate clients or others?
Yes. So Professor Pearlstein has referred to something called the Article 3 Coalition, which is an organization of former federal judges appointed by both Republican and Democratic presidents. So it's definitely nonpartisan, or you could call it bipartisan, take your choice. But the bottom line is we've been working as a group to encourage all kinds of individuals and businesses and organizations to sign on, so to speak. So we now have over 750 individuals and legal organizations, including hundreds of individual attorneys, over 70 former judges, dozens of organizations, Deborah said, including the New York City Bar Association, which is a huge and prominent bar association, over 50 current or former big law attorneys, and many former general counsels of prominent corporations, including Pfizer, Heineken, Eli Lilly, American Express, etc. So we are doing a tremendous, I'm sorry for the background noise, but it can't be helped. Anyway, we're doing a lot of outreach to encourage more and more entities and law firms to sign on. It takes work, though, until you get people to be familiar with this concept and to want to join us. But that's what we're doing. We're trying hard to push it out, so to speak. And we think that law students, and I don't know how many of the folks on this call might be law students, how can they play a role? I think that's an important question. One way is to express that they care. When they do go to interviews with various law firms or entities, government entities or businesses or law firms, they should say, by the way, have you signed on to those principles of independence of legal profession? Because if you haven't, I'm not sure I'm comfortable here. So if law students speak up, and again, for the third time, silence is not an option. So if law students speak out, that will help us with the principles. I want to take a moment because I think it's important. I won't be long, but we have talked about the rule of law. And I know that, as you said, Deborah, Greg has written wonderful pieces on this, and so he could probably summarize even quicker than I can. But I think it's important in tonight's webinar to just spend a minute being sure we have a common understanding. So I'm going to just do it. It means that as a constitutional democracy, we adhere to the rule of law, not of men. So I look at that both ways. We abide by the law. We agree to abide by the law as a society, whether it's a statute, civil or criminal statute, whether it's a judicial decision, which is final, by the way, unless and until it's overturned by the Supreme Court. So it is entitled to respect immediately. When a court speaks, it's supposed to be respected. That's the rule of law. Yes, there's appeals, and it can go all the way up to our highest court. But on the way, unless there's a stay, that's the rule. That decision is the rule. Now, what's the opposite of that? Being ruled by men, not by law. That means a king or an autocrat, essentially an unchecked ruler who can issue his own rules any day, whatever he wants. That's what he can do whenever he chooses to. That means there's no predictability. There's no reliance on settled legal principles. So when you define the rule of law, you look at it from both sides. What is it to be governed by judicial decisions and statutes? What is it not to be governed by that, but by the whim of an individual ruler? And this country was founded on the principle that it was not going to be subject to a ruler. It rebelled against Britain and its king, who could issue commands to its subjects, which we were, the colonies, and that's over. We said, that's not us. That's not our system. So it is our job as lawyers and judges to preserve what is so important in our founding principles and our founders. As you said, Greg, you represent a lot of conservatives, but they constantly cite the founders, and so do I. The founders believed in separation of powers, checks and balances, and co-equal branches of government. Co-equal. That means the judiciary, legislative, and executive, not one above the three. We can't have that because that's not the rule of law. Thank you for allowing me to do that, Deborah.
You're welcome. Let me come back to the discussion of the sort of strategies and ask Neil again. So we talked some about the role of students, and I've put in the chat some links for students that might be of particular interest. But Judge Shinlin also mentioned signatories of general counsels from some of these major corporations. As you know, corporate general counsels are often the ones, I think, to make decisions about which outside law firms to hire in representing corporate clients, given their potential strategic value, right? The notion that corporations could say, look, we'd prefer hiring law firms that embrace either principles like these or that fight back against attacks on their independence or whatever. Given the potential strategic value of sort of corporate clients in this space, what can you tell us about any signs of organizing on the corporate side? And also, what do you think is the best argument that corporations should prefer hiring firms that embrace those views?
Yeah, well, Deborah, I'll make two observations. First of all, I think in some ways, in what I'll describe as big law, there's been a massive realignment over the last year on who people are hiring, on where recruits are going, and law firm partners have moved from one place to another, depending on what their practice is. Sometimes they might go to a firm that struck a deal because they believe their deals will be more easily processed when they're dealing with the government. So I mean, I think that that's just a collateral effect. Now, following the founding of Law Firm Partners United, there was another group formed called General Counsels United. And it was general counsels, about 700 of them around the country, that all decided they were going to work together, and in a similar but also different way to what Law Firm Partners United was doing, to talk about ways that they could act as general counsels to help promote issues on the rule of law. And for them, it's a fundamental thing, right? Because if they don't have a system of governance that they can understand, how can they advise their companies on what to do or not do? I would say that there is a divergence on that, though. There are some companies that are very heavily regulated or are very, very reliant on interactions with government for their business to operate more effectively. They fall into a very different place on who they're going to pick for their representations, even if they disagree with what the government's currently doing, because they have a commercial need for it. But General Counsels United has been very effective on mobilizing people about talking about how are they going to make decisions about hiring law firms, all things being equal. I don't know all of the secret sauce they have going, but I know they've been very mobilized and active, and I've become good friends with them. There are certainly clients who are asking the hard questions. But there are also a lot saying, we need to make sure that you're out of harm's way. The reality is, though, because of this realignment, if you look at all the AmLaw announcements, all the law firms are doing just fine. It's not like it's not like any of them are having a huge commercial impact. They decided what was right for their business, or they decided they needed to fight or align themselves. But legal industry wasn't shut down. What I will say is that the executive orders were at some level the tip of the iceberg on the attack on the rule of law issues, because just as the interim effect of representing people against the government is real, pro bono representations have been harder for nonprofits to get people to take on. That is a fact. And when those folks have a harder time finding lawyers, that means less cases are being brought and the boundaries are not tested as much. Whatever side of the aisle you fall on, that is unfortunate. The second thing is that, and I know this audience will resonate with, the caps on law school loans. And the caps on law school loans is a significant issue because the people most likely to enter public interest are those people who are like first generation members of their family, who are going to law school. And now it is going to become harder. Austin and I sit on the board of a group called Access Lex. And we've been innovating ideas of how to make sure we can help people out to kind of cross that transom at the end if they exceed their loans. The EEOC letters and the FTC letters about the so-called DEI practices. And this is where corporate America and law firm America differ. Law firms have taken that very seriously, and there have just been some reports over the last 3 months, or not even last 3 months, last 2 months, that summer hiring demographically has changed markedly. People are dropping out of programs where they'll report numbers or anything like that, and just there's less representation that's occurring across the board. And when it's not reporting, you just don't notice. You can't keep track of what's going on, and people don't pay as much attention to it. All of these things at one level or another frustrate the way that law gets advanced because of the people who are entering positions of influence or doing these sorts of work. And it's a much more subversive attack, right? Because you're not just saying if you represent someone on an unpopular cause, that then you can't do it. These are going after kind of the underlying roots of it that I think are pretty problematic.
So let me pick up on a couple of things you said in that question and then pose a question sort of to the whole panel. Just to fill in a little bit, you mentioned the FTC letters, and just in case folks don't know, so recently in the last month or so, the FTC sent out letters to dozens of law firms, including many of the firms that had entered deals with the administration to try to sort of resolve issues or potential attacks, saying, look, if you are any part of an agreement that we will consider diverse candidates in hiring at our law firm at all, we think you may be liable to antitrust enforcement, essentially threatening the firms with antitrust enforcement unless they got themselves out of any sort of commitment to consider diverse candidates in hiring. So the threats very much continue, both against the firms that fought back, the firms that signed deals with the administration, and similarly, the sort of ongoing unwillingness of firms to sort of take on clients continues. So the problem remains very live. And I guess one of the arguments that I hear a lot from law firm lawyers, not the ones in your coalition and not the general counsel's coalition, but from not just lawyers, but from Americans kind of in academia and outside, you know, we should just keep our heads down. This is going to pass. There's going to be an election in November. Probably control of at least one house of Congress will change. This is this sort of standard blue and red fighting. And when there's a new administration, as there will be at some point, we will, change our practices then. And in the meantime, we'll sort of protect the business that we're in. So I guess I'd like to invite any of you to respond, but since I was sort of responding to Neil, let me start with him and then Greg, and then we'll come back to the judge if you have any response to sort of that argument.
So this was an argument that was really raised when the first executive orders came out, was, this too shall pass. It's a limited in time thing. But, I always think about the role of precedent, at one point in time, one administration was appointing judges who were maybe in their 50s, mid 50s. And then the next administration came in and said, no, we want to have people on the bench longer. So we're going to put them in, we're going to appoint people who are in their 40s. And then the following administration after that, when it changed hands, said, yeah, we need to have people on the bench longer. So we're going to do that. That was a perfectly legitimate exercise of political discretion. There are plenty of qualified people in their 40s. This one, however, creates utter chaos in the sense that when this passes, there is now a practice that has been legitimized as a political act to go against people based upon whatever party is in power. And at that moment in time, it frustrates the ability to pursue the issues that whatever side of the aisles, on opposing it, will be more reluctant to challenge and advance kind of what the basic set of rules are. And it goes to the point that Judge Scheindlin was pointing out, it becomes more of a rule of men rather than rule of law, because it's really who got the most votes, not, what is the most lawful thing to do under our Constitution.
Let me ask Greg if he wants to jump in, and let me also just mention that if folks have questions, please put them. It's a little question mark at the bottom of the screen. It says Q&A. Please feel free to put your questions in there, and we'll hopefully set aside at least 10 minutes at the end to deal with to address some of those if we have any. So Greg, do you hear that argument from folks, and how do you respond?
Yeah, no, I hear that argument from folks in law firms with this specific issue, and then in lots of other contexts with various assaults on norms and the rule of law. And I would echo everything that Neil said. I mean, there's real problems with setting precedents, and people really need to interrogate themselves. It's very easy to tell yourself a story that you are being responsible by avoiding fighting today. Because in the long term things are going to work out, and people keep telling themselves that sequentially, and then you end up in a really dark place where it's too late to fight. I mean, it's just people really need to draw lines, and this is a very, very good place to draw a line. Otherwise, you're not going to like where you end up. I don't think for 1 minute we should believe that any of this is just episodic or temporary. I think it's setting new baselines every day.
So I want to respond also.
Yeah.
So look, this is what bullies count on, whether it's a bully in the playground, at an elementary school, or whether it's a grown-up bully in our society. They count on the fact that people will not resist. And once they don't resist, they take a step further. It's never enough. So you test the waters, you put something out there that is clearly wrong, clearly unconstitutional. You don't get resistance. You say, hey, good, I got away with it once. I'll do it again. You do it again. So you don't just go after lawyers, you go after the media, you go after various segments of society one by one by one. And if you don't get resistance, you're going to go further. You're going to go further. So, it's a process that has to be stopped. Otherwise, there's going to be continual overreach. And that's what we mean when we say threats to our democracy. What do we mean by that phrase? Is that our democratic institutions are under attack. And if we don't say stop, there's going to be a new effort tomorrow. So I understand today that after the administration wasn't able to pass the SAVE Act, which would have cut back on voting rights, so having not been able to do it through Congress, executive order was signed. That's going to restrict mail-in voting in a very big way. So I'm glad you have confidence about the upcoming midterms, Professor, but I'm not sure I do, because if we do not have fair and free elections, then we won't have the outcome that such elections would bring. I want to talk for a minute about the attacks on judges and how that delegitimizes the third branch of government. Judges have been called lunatics, traitors, not, I don't know other words, but there's a whole list of them that they've been called. What does that do to public perception? They've been called political hacks. I think that too. Political hacks, traitors, lunatics, lots of other words. And it delegitimizes that branch. And it also threatens their personal security, because if the leader says things like so and so should be arrested, so and so should be behind bars, that's not how you fight a judicial decision. The only way to do that is to appeal. You don't like the decision of a lower court, appeal. But you don't say the judge should be impeached, the judge should be behind bars. That isn't the way we do it in this country. You appeal, and if you win, you win, and if you don't win, you don't win. But there's a process. So this delegitimizing of our institutions is the threat to our democracy.
Let me just follow up on that really quickly. Just in the last hour before this webinar, there was a district court ruling on an immigration matter, and Stephen Miller, the president's chief advisor, said we live under a judicial tyranny.
Oh.
Tonight, when the president signed the SAVE Act executive order, or the mail-in voting executive order that you're referencing, he said the only way this could be stopped is by rogue judges, very, very bad people, very, very bad judges. That is the only way his executive order can be stopped. I mean, so this is like a very deliberate, sustained campaign of delegitimization, which bothers me. And look, as important as judges are, the rule of law cannot be saved by judges alone. It requires a cultural commitment to these institutions and these norms for all of us. I mean, it starts with the lawyers, but really everybody has to say no to this sort of thing and has to believe in the process we have. It's one of these kind of magic things like Tinkerbell. It's really it's got all its power when you believe in it, and we as a country need to believe in these processes and these institutions that are imperfect but carry so much weight for all of us.
I want to say, just in response to both the judge and Greg, that rhetoric that you were just quoting about the tyranny, the judicial tyranny, is rhetoric we've heard increasingly from not only the administration, but members of Congress and others. And it's familiar if you study sort of comparative autocracy and comparative democracies, or democratic backsliding, as my political science colleagues would call it. In Turkey, for example, as it was sliding backwards from democracy to a more autocratic form of government, the courts were among the last functioning sort of constitutional democratic institutions. And the more they were pulled into sort of contemporary debates, the more they became targets of the sort of ruling regime for attacks on the grounds that they themselves were anti-democratic. So it is a threat that is it a threat that is familiar, at least in these spaces? We have one question from the audience, and I'll reframe it just slightly, but at the heart is a question we have a couple of questions, but let me start with this one. It's asked by a psychologist who says, what is the human psychology that drives people, and maybe that drove the firms, or that drive people to sort of make these decisions, or the decision that easier to not engage, easier to not push back, easier to sort of keep my head down and go with the flow. Even though, and as we saw, Neil, from the coalition work that you described, lots of individual lawyers see the danger and see it very similarly. Do you have any sense of what people were thinking? What people, you talked to Judge Shenlin, you talked to other judges and other former judges, and Neil, obviously, in the law firm front, and Greg in various circles, including all of those. Any thoughts about what the psychology is here?
I think there's an emotional safety in not taking a position if you don't have to. People don't like feeling like they're putting a target on their back, right? That's an unsettling thing, People have families they have to take care of, and they worry about those things. And I've heard all of those things from people that sat by the sidelines. I don't agree with it personally, but that's what I've heard.
Well, I want to push back on that a little bit to think about the No Kings marches, because the first one was big, the second was bigger, the third drew 8 million, I'm told, Americans out. I think people may have started with that psychology of put my head down, fear of resistance, target on my back. Now they're saying enough is enough. Stop. And the only way to stop, I think, is what we saw in Minnesota. I think Minnesota was a great example for the country. The people went to those streets in the worst cold recorded ever, and they came out and they protested. And you know what? The troops left. ICE left. The president folded. He did one of his, well, we call it taco, but anyway, it doesn't matter. He folded, and that was the end of that. And Minnesota became sort of a free state again. But it showed the power and the importance of resisting. So yes, you start with what you said, the fear, you don't want to put a target in your back, all of that. But you quickly realize what I said before. If you don't stop it, you're going to get worse and worse and worse. So you begin to resist. And I was very impressed this last week with the 8 million Americans coming out. And if there's a fourth one, there'll be more.
Yeah, no, I agree with that. I think once you see a number of people, then more people join. Success begets success, right?
That's right.
And I think fewer people stand on the sidelines when they realize there's an entire community aligned.
That's right. When you see your neighbors, that's what they kept saying in Minnesota. It's our neighbors. When you see your neighbors going out and marching, you say, why not me too? And you do.
So let me ask one last question of the panel, just by way of conclusion. We've mentioned just in the course of this discussion, challenges to the election, enormously controversial and difficult sort of different policy initiatives that the administration has undertaken, certainly with respect to immigrants in the United States, and many other things as war and a host of issues that one might be concerned about. How do you rank? People have limited time. People have jobs and families and work. And sometimes lawyers are your neighbors and sometimes lawyers aren't your neighbors. How do you rank this set of issues? How do you think people should rank this set of issues in their sort of order of priorities for where they put their scarce sort of pushback resources? Do I call the corporation I frequent and say, hey, I wish you would represent another, I wish you would pick another law firm to represent you. I wish, you would approach this in a different way. Or do they deploy their resources elsewhere? Any of you for sort of concluding?
I'm just going to start with an anecdotal thing. So, my dad came to the United States on a boat into the port of San Francisco in the early 1960s. And he went to engineering school. He built things for the Defense Department. My brother's the acting chief medical officer of the Naval Reserve. Like, I have never served my country. My family has. And when I decided I want to go to a liberal arts college and then go and get a law degree, that was just about the worst thing that I could have done for my immigrant parents. My brother's got two engineering degrees and a medical degree. And I was going to go and be the guy that my parents see on television. advertising for personal injury accidents. When the American lawyer thing happened, my parents wanted to go. And when people started coming after me for forming law firm Partners United, my dad said to me, "You need to keep doing this." I think the standard is, would you be proud to tell your parents what it is you're doing for our country? And it's not a more complicated indicator than that.
Others concluding thoughts?
You know, they always say that what people seem to care most about are their pocketbook issues. So they start with that reality, but they quickly begin to realize the impact of policies on their pocketbook. And that as soon as they begin to realize that connection, they wake up. And you'll see this. If you look at public opinion polling, you'll see a decrease, a real decrease in support for this administration. Why? Because of the policies that have caused some of the pain that they're feeling. And they realize that it's mean-spirited. It's mean-spirited to deny people health care. It's mean-spirited to deport your neighbors who are here legally. There's a lot of mean-spirited behavior going on. And I think we are struggling here to be very inclusive, Greg. You know, I'm not speaking as a one side or the other side, but we can't be ignorant of history. And I worry about that. You raised that, Deborah, in your last comment. It's very important. For those of us who do understand history, we know that if you don't stop what's going on, it will get worse. That's my final comment.
Yeah, no, and I would just kind of echo a lot of that. That it may seem academic or complicated, but it's not that complicated. It's the absolute truth that everything that people value, their safety and their security, depend on the rule of law. The rule of law in America depends on the separation of powers, and that separation of powers absolutely depends on an independent judiciary that an independent legal profession can bring cases to. That I mean, it is truly the keystone of everything that we enjoy in this country, and from pocketbook issues to basic personal safety. So this is an important project. I'm glad law students are hearing this and that law schools are putting time into this conversation, because it really does matter that much to everybody.
Thank you. And I know we had some last questions. I'm grateful for some of our panelists for responding in the chat. I regret not being able to get to it, but I also swore that I was going to bring this to an end at 7 o'clock. And I have a few last things I need to say. First of all, enormous thanks to the panelists for taking the time, to all of you for joining us for this incredibly important discussion. The next episode in the series will be next week, hosted by a different institution, but also under the leadership of the AALS, and it will focus on specifically challenges to judicial independence. So in many respects, it will pick up where this panel left off. I encourage everyone to look through the chat. There are links to lots of useful things to read and information, and the principles of professional independence that you can sign on to this very evening if you are a lawyer or a law professor or anybody in the legal profession and have not already done so. We look forward to being in touch with you, I'm sure, going forward. Thank you again, and we'll look forward to seeing everyone next week.
Thank you.
Thank you.
Thank you,
Thanks for
Deborah.
having me.
Thank you.